everyone, I'm Aratrika Bhomik and I welcome you all to the fourth episode of the much awaited LiveLaw's exclusive series titled 100 Important Supreme Court Judgments of 2022. For those of you who are not aware, it is a 5-part series where we cover 20 important judgments in each episode. If you haven't watched the first 3 episodes of the series, you can see the description box below where the links to the episodes have been provided. So without further ado, let us begin. A Supreme Court bench comprising Justices A.M. Khanwilkar, A.S. Oka and C.T. Ravikumar in the case titled All India Hajj Umrah Tour Organizer Association vs. Union of India dismissed a batch of petitions filed by various private tour operators seeking exemption from the goods and service tax for the Hajj and Umrah services offered by them to pilgrims travelling to Saudi Arabia. The Supreme Court in the case titled Vijay Madan Lal Chaudhary vs. Union of India has upheld the provisions of the Prevention of Money Laundering Act of 2002, which relate to the power of arrest, attachment and search and seizure conferred on the Enforcement Directorate. The Supreme Court upheld the constitutionality of the provisions of sections 5, 8, subsection 4, 15, 17 and 19 of the PMLA, which relate to the power of the ED to arrest, attach, search and seize property. The court also upheld the reverse burden of proof under section 24 of the Act and said that it has a reasonable nexus with the objects of the Act. The court also upheld the twin conditions for bail in section 45 of the PMLA and said that the Parliament was competent to amend this provision in 2018, even after the Supreme Court's prior judgment in the case titled Nikesh Tharachand Shah, the case where it had struck down these two twin conditions. The bench also said that the Parliament is competent to amend section 45 in the present form to cure the defects pointed out in this particular Supreme Court judgment. Emphasizing on the need to revise the pay structure for judicial officers, the Supreme Court in the case titled All India Judges Association vs. Union of India and others ordered for the implementation of the enhanced pay scale as recommended by the Second National Judicial Pay Commission with effect from January 1st, 2016. The Supreme Court bench of Chief Justice of India N.V. Ramana, Justices Hema Kohli and Krishna Murari had also directed the centre and the states to pay the arrears to the officers in 3 installments, 25% in 3 months, another 25% in the next 3 months and the balance by June 30th, 2023. The Supreme Court in the case titled Akela Lalita vs. Sri Konda Hanumantha Rao has observed that a mother who remarries after the death of the biological father can decide the surname of the child and include it in her new family. The Supreme Court bench comprising Justices Dinesh Maheshwari and Krishna Murari set aside an Andhra Pradesh High Court judgment which had directed a mother to change the surname of her child and also to show the name of her new husband in records only as a stepfather. The Supreme Court of India in the case titled Jai Prakash Tiwari vs. State of Madhya Pradesh observed that while examining an accused under section 313 of the CRPC, all the adverse evidence has to be put in the form of questions so as to give an opportunity to the accused to articulate his defense and give his explanation. A bench comprising CJI N.V. Ramana and Justices Krishna Murari and Hema Kohli had observed, and I quote from the judgment here, if all the circumstances are bundled together and a single opportunity is provided to the accused to explain himself, he may not be able to put forth a rational and intelligible explanation. The Supreme Court also clarified that such an omission does not ipso facto vitiate the trial unless the accused fails to prove that grave prejudice has been caused to him. Reiterating the importance of the courts dealing with the victims of sexual crimes in a sensitive manner, the Supreme Court in the case titled XYZ vs. State of Madhya Pradesh has issued a slew of directions to the trial courts to avoid agony and harassment for women who file complaints of sexual harassment. A Supreme Court bench comprising Justices D.Y. Chandrachud and J.B. Pardewala directed that in-camera trials should be allowed in all cases relating to sexual harassment. As per Section 327 of the Code of Criminal Procedure, in-camera trials are mandated only in rape cases. This ambit has been expanded by the Supreme Court in this judgment. In a case of conflicting dying declarations, the Supreme Court of India in the case titled Makhan Singh versus the State of Haryana relied on the one dying declaration which was recorded after a medical examination with regards to the fitness of the deceased person. The court explained that the difficult question before it, and I quote from the judgment here, in the present case we are faced with two dying declarations which are totally inconsistent and contradictory to each other. Both are recorded by judicial magistrates. A difficult question that we have to answer is which one of the dying declarations is to be believed by the court. The bench comprising Justices B.R. Gawai and Justice P.S. Narasimha also opined that the Supreme Court was required to examine as to whether a dying declaration was true and reliable, as to whether it had been recorded by a person at a time when the deceased was fit physically and mentally to make the declaration, and whether it had been made under any prompting, duress or distress. In a judgment having far-reaching impact in commercial litigations, a Supreme Court bench comprising Justices K.M. Joseph and Rishikesh Roy in the case titled M.S. Patel Automation Private Limited and others versus Rakheja Engineers Private Limited declared that Section 12A of the Commercial Courts Act, which mandate pre-institution mediation, is mandatory, and that suits which are filed violating this mandate are liable to be rejected at the very threshold under Order 7 Rule 11 of the Code of Civil Procedure. The Supreme Court was, however, of the opinion that a declaration to this effect will be made effective from August 22, 2022. A bench comprising CJI N.V. Ramana, Justice Krishna Murari and Hima Kohli in the case titled Union of India versus Ganpati Dealcom Private Limited declared that Section 3 subsection 2 of the Benami Transactions Prohibition Act of 1988 as unconstitutional on the ground of being manifestly arbitrary. Section 3 subsection 2 prescribes the punishment for entering into a Benami transaction. The court further held that the Benami Transactions Prohibition Amendment Act of 2016 cannot be applied retrospectively. The Supreme Court held that the 2016 amendment cannot be held as merely procedural in nature. Observing that the purpose of a judgment is not to confuse or confound the readers, the Supreme Court in the case titled State Bank of India versus Ajay Kumar Sood has urged the courts and tribunals to provide an easy-to-understand analysis of the issues of law and fact in their verdicts. A Supreme Court bench comprising Justices D.Y. Chandrachud and A.S. Bopanna made this crucial observation while dealing with a judgment of the Himachal Pradesh High Court, which was found to be incomprehensible. In a notable order in the case titled Deepika Singh versus Central Administrative Tribunal, the Supreme Court of India has made certain significant observations which expand the traditional meaning of what a family is. The Supreme Court has observed, and I quote here, familial relationships can take the form of domestic, unmarried partnerships or queer relationships, while holding that atypical family units are also entitled to the equal protection of law. A bench comprising Justices D.Y. Chandrachud and A.S. Bopanna made these observations in a judgment while granting the relief of maternity leave to a central government employee regardless of the fact that she had availed childcare leave for the children of her husband from his earlier marriage. In a significant judgment in the case titled Oil and Natural Gas Corporation Limited versus Afcons Gunanusa JV, the Supreme Court of India held that arbitrators do not have the power to unilaterally fix their fees without the consent of the parties. The Supreme Court further held that the fee scale prescribed under the 4th schedule of the Arbitration and Conciliation Act of 1996 is not mandatory. In a batch of petitions challenging the 2021 amendment carried out by the Uttar Pradesh government in the Standing Policy regarding premature release of live convicts 2018, the Supreme Court of India in the case titled Rashidul Jafar versus State of UP and another passed several directions regarding premature release. The decision of the Supreme Court of India would have an impact on the consideration of the remission plea of about 512 convicts who are currently undergoing life imprisonment. The Supreme Court of India in the case titled Mohammed Latif Magre versus Union Territory of Jammu and Kashmir has suggested that the Union government should consider enacting an appropriate legislation on exhumation. A Supreme Court bench comprising Justices Surya Kant and J.B. Pardiwala observed, and I quote here, "The right to dignity and fair treatment under Article 21 of the Constitution is not only available to a living man but also to his body after his death. His family members also have a right to perform the last rites in accordance with religious traditions." The Supreme Court of India in the case titled State of Telangana versus B. Subba Rayadu has observed that there is only one domicile, that is domicile of the country, and that there is no separate domicile for a state. The Supreme Court bench of Justices Indira Banerjee and V. Ramasubramanian observed that state reorganization laws cannot take away from citizens the right to reside and settle in any part of the country. The Supreme Court in the case titled BCCI versus Cricket Association of Bihar has allowed the amendments proposed to the Constitution of the Board of Cricket Control of India, that is BCCI, to relax the mandatory cooling off period requirement. Now the cooling off period of 3 years will apply only if a person serves 2 consecutive terms at the BCCI or the state association. Also, the cooling off period requirement will apply at that particular level, that is either at the state association or the BCCI. In other words, the cooling off period requirement will not bar one from seeking election to the BCCI immediately after serving 2 consecutive terms at the state level. A Constitution bench of the Supreme Court in the case titled Trimurti Fragrances Limited versus Government of NCT of Delhi ruled that a judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority. To illustrate, the judgment of a 7-judge bench delivered with a 4:3 majority will prevail over a unanimous 5-judge bench. A 5-judge bench comprising Justices Indira Banerjee, Hemant Gupta, Surya Kant, M.M. Sundaresh and Sudhanshu Dhulia gave this particular ruling. The Supreme Court of India in the case titled Securities and Exchange Board of India versus Abhijit Ranjan has held that merely because a person was in possession of unpublished price-sensitive information at the time go trading in securities, it cannot be held that the transaction becomes the mischief of insider trading unless it is established that there was an intention to take advantage of the information. A distressed sale of shares will not become insider trading merely because the person was in possession of unpublished price-sensitive information. The Supreme Court of India in the case titled Sonadhar versus State of Chhattisgarh has opined that all persons who have completed 10 years of sentence and whose appeals will not be heard in the near future should be enlarged on bail unless there are other reasons to deny them bail. A division bench of Justices Sanjay Kishan Kaul and Abhay S. Oka was considering a batch of petitions of live convicts in jails whose appeals have been pending before various high courts of the country. The Supreme Court has expressed prima facie doubts about its 2015 judgment in the case titled Reserve Bank of India versus Jayantilal N. Mistry, which had held that the Reserve Bank of India was obliged to disclose defaulters list, inspection reports, annual statements, etc. related to banks under the Right to Information Act. A 2-judge bench comprising Justices B.R. Gawai and C.T. Ravikumar prima facie observed that Jayantilal Mistry case did not take into consideration the aspect of balancing the right to information and the right to privacy. The Supreme Court bench also noted that privacy has been declared to be a fundamental right under Article 21 in a subsequent judgment delivered by a 9-judge bench in 2017 in the Puttaswamy case. Thank you, dear viewers. We will shortly come back with the final episode of the series. Stay tuned to LiveLaw for more such updates.